Good afternoon, everybody, and welcome to this webinar. I am really excited to be talking about the new Washington My Health, My Data Act, MHMD Act, with Mike Hintze. Mike is a leading partner with Susan Hintze of Hintze Law. This is a boutique law firm that focuses on privacy and data security. It has grown incredibly over the years and now is actually quite large with quite a number of lawyers. Previously, he was at Microsoft for, I believe, about 18 years as privacy counsel there. And then he also teaches privacy law at the University of Washington. And I thought of Mike to discuss this law because he's written quite a number of blog posts. Plus, he is living in Washington, so follows the law there very closely. But he wrote a series of blog posts about this law, pointing out how notable it is. In particular, I believe you had said you think it could very well be the strongest privacy law in the United States. And so I wanted to, I guess, just to start off at that very broad level, tell me why you think this law is so notable, why you think it's so strong.
Well, a couple of reasons. One, it's just incredibly broad in its scope. And a lot of people who have heard about this and see the title of it and have heard the talk about it as being a health-specific privacy law may not fully understand how broad it is, how much data it encompasses and what kinds of entities it encompasses. And we can dig into that more in a few minutes. But it is incredibly broad. It touches a lot of companies, a lot of nonprofit organizations. It's not limited to commercial entities. And the scope of data that it regulates is incredibly broad. And I think a lot of companies will be surprised to learn that they are or will be regulated under this law. Beyond that, it has some substantive obligations that go beyond what we've seen in other laws. There is a very broadly applicable opt-in consent requirement, and they use GDPR-like language around specific, unambiguous, informed, explicit action to constitute valid consent for collection, uses, or sharing of data that go beyond what's necessary to provide a consumer requested service. So it could potentially touch a lot of different data processing operations. Beyond that, there's an even higher consent standard called authorization for anything that would constitute a sale of personal data. And it uses the broad definition of sale from the California Consumer Privacy Act, CCPA. There are data subject rights similar to what we've seen in other laws, but again, they go beyond that. There are access rights that include, among other things, an ability to access a list and the contact information of every third party with which consumer health data has been shared. There is a deletion right that includes not only data that has been collected and is in active systems, but includes backup and archive systems. And more importantly, it does not include the common exceptions we see in virtually every other privacy law, including situations where retention of the data is required by law, thereby setting up some catch-22 situations where companies may have to choose whether they violate a data retention obligation or violate a data deletion request as is required under this law. There's strong prohibition on geofencing, and then significantly more so than any of the comprehensive privacy laws, or distinct from any of the comprehensive privacy laws we've seen passed in recent years, there is a private right of action under this law. So we will see plaintiffs' counsel aggressively pursuing cases in this space, which, I think certainly increases the risk profile and the potential for liability for many organizations.
So, wow, there's quite a lot here, and I'd love to drill down on various parts of this law. And I guess first, just get a sense of why. Um, what is the animating interest behind passing this law? Why did Washington do this? And what is the goal of the law? What's the purpose of it?
Yeah, it's an interesting question. I think there's probably two motivations. And just to provide context, as you know, there has been proposals in Washington State for comprehensive privacy legislation for a number of years now. And in fact, what was the never passed Washington Privacy Act became the model for Virginia and subsequently the up to 11 or 12 other states that have passed similar laws at this point. So privacy has been on the agenda of the Washington State Legislature for a long time. It never got through, and so I think one motivation was perhaps a more focused piece of legislation might have a better chance. And there were a couple of drivers behind this particular bill and this particular approach. One is a longstanding issue that has been widely discussed about the gaps left by HIPAA. HIPAA covers specific types of covered entities and the information that's processed by those covered entities, healthcare providers, hospitals, pharmacies, health insurance plans, et cetera, and data that's used for the provision of healthcare, treatment of health of patients, and billing for such. But that leaves a lot of health data that's not covered, data that's collected by fitness apps, data that's collected by a variety of websites. And that's been an ongoing, long-standing discussion about a need or a desire or a need to enact stronger protections to protect that health data that's not captured by HIPAA. And then Dobbs happened. Dobbs overruling Roe v. Wade, putting reproductive health care at risk in many parts of the country. At the same time, a lot of the similar political forces putting gender-affirming care under threat in many parts of the country. Washington being a very progressive state, wanting to take a stand to protect the privacy of information relating to people seeking reproductive health care, seeking gender-affirming care, obtaining that care. So those were multiple motivations, and one is very focused, one is a bit broader. But as I mentioned before, if you look at the actual language and impact of the statute, it's even very much broader than what you might imagine if those were ultimately the goals of this legislation. It's not limited to just reproductive health care data. It's not limited to just gender affirming care data. Indeed, it's not even limited to what might be generally considered more sensitive categories of health data. It is a very expansive definition, and a lot of things can fall into the definition of health data that a lot of people might not even consider related to health.
So let's drill down on first on the scope of who is covered, and then we'll get to the data part, which I think is a really interesting question of what exactly is health data and how do we define it in the modern world where inferences can be made about anything. But first, just it's interesting how its scope. It's extraterritorial, so it applies to entities outside of Washington. Yep. And it unlike the other state privacy laws, it does not have a size or thresholds for businesses. Either no revenue thresholds, as I understand it, or no size. So just a single person, with a small solo LLC would be covered. Just like Meta would be covered, or a big company. It would be any company of any size, of any revenue. But what I also think is also interesting is, what does it mean? There's the typical, do business in Washington, but there's this idea of targeting, which could possibly encompass a little bit more than that. curious what your thoughts are on that, and exactly, who would fall under this law.
Yeah, it's a great question. One, it applies to both commercial entities and nonprofits, so it's not limited to just commercial entities as some privacy laws are. So nonprofit organizations will be covered by this law. There is actually a definition of small business, but it doesn't change the substantive obligations. The only distinction is that small businesses have a date where it comes into effect that is 3 months later than other regulated entities. So substantively, the obligations that will be imposed on, as you said, even one person, small businesses are the same obligations, the same substantive requirements. and before I get to the definition of a regulated entity, I do want to point out that two of the provisions don't even apply to regulated entities. They apply to all persons, including natural persons. The prohibition on geofencing applies to all natural persons, in addition to legal persons, as does the requirements around authorization for data sale. So you don't even have to be incorporated as an LLC. An individual can be regulated under some elements of this law. So a regulated entity that all of the obligations would apply to is an entity, as you said, that conducts business in Washington, or that targets products, or that produces or provides products or services targeted to consumers in Washington. And you were right to key on the word targeted, because that doesn't necessarily mean you're doing anything specific to attract Washington entities, and in fact, or Washington consumers. The Attorney General issued an FAQ a few weeks ago to provide some clarity around some of the areas of ambiguity. And with respect to this, who is a regulated entity, they used language like provide services to consumers in Washington state. So presumably any website, any online service, any app that is available to consumers in Washington state is potentially enough to make the entity a regulated entity under this act.
So, I have a blog and I have a website. That would be covered. I'm blogging and just writing about things. Is that a service, or does it have to be connected to anything? Because I guess it could be a free service, right?
It doesn't have to be a paid service. It can be a free service. I think providing information on the internet is a service. So your company Teach Privacy, to the extent it collects consumer health data, and I'm sure we'll talk about what that means in a minute, would be covered as a regulated entity potentially. Your university could be covered as a regulated entity. Almost certainly is covered as a regulated entity, given the scope of the consumer health data that's potentially covered by this law.
Yeah, so let's drill down into. Well, actually, but before that, the law does make exceptions for certain existing federal laws, like FCRA, GLBA, HIPAA, and in particular, HIPAA is probably the most relevant. Suppose I'm a HIPAA-regulated entity. I'm a hospital. And is this an entity-wide exclusion? So if I'm HIPAA regulated, the entire enterprise is excluded, or is this just any data that would be HIPAA regulated would be excluded, but any data that would not fall under HIPAA, even if I'm a hospital or otherwise regulated by HIPAA, then would be covered?
It is a data exclusion. It is not an entity exclusion. So the data is regulated under one of these enumerated federal laws, and then there's some Washington laws that are listed as well. Then that is excluded from this law. The entity is not excluded. So if the entity is collecting other data that is not regulated under one of those enumerated laws, like HIPAA, but nevertheless would be considered consumer health data under this very broad definition, that would be regulated under this law.
It does set up a very weird thing where, in some ways, this law might be stricter than HIPAA. And so I could be ironically, if data is covered by HIPAA, it gets less protection than if it's not covered by HIPAA, even if it's held by the same entity. But this raises the big question of, what exactly is the type of data that's covered? And in particular, this law is trying to get at health data, but it has a very broad definition of health data. And I think, there's a well-meaning basis in this, and that, in the modern age, it's very easy to make inferences about health outside of what's in a medical record. So obviously, a medical diagnosis would be health data, but there's a lot of things that could also be relevant to health. And if the goal is, protect people's treatment for reproductive health, for gender affirming care, and so on, we need to go beyond just doctors' information, because that information could be inferred from things that people do, things that people buy, or using health apps that collect a lot of information about people's day-to-day health. So I think the law is trying to be expansive so that there aren't areas where this could readily be inferred by an algorithm, and then falling outside the scope of the law. But the consequence, I think, is that the definition of health data becomes incredibly broad, perhaps encompassing almost anything. And I'm curious what your thoughts are on the scope of this.
Yeah, I think that's right. There's a number of aspects to the definition of consumer health data that you could imagine. Certainly arguments, and they don't even have to be particularly creative or aggressive, that would cover, as you said, almost anything. It does cover inferences. So, and they repeat repeatedly, and when I say they, the supporters of the bill, the Attorney General's office, this was an Attorney General requested bill, and the Attorney General played a heavy role in drafting and shepherding it through the legislative process. The legislators who were the sponsors and supporters of it repeatedly cited the 2012 incident with Target, when a young woman made some what might seem fairly innocuous purchases, some vitamins, some lotion, a large handbag, and their algorithm created a pregnancy prediction score and showed her some targeted advertisements, or to send her some targeted advertisements indicating, based on the assumption that she was pregnant. So the language captures those kinds of inferences. Certainly the inference of pregnancy or the inference of a health condition is covered as consumer health data. The language suggests, and this is reinforced by the language that was in the FAQ, that the underlying data that was used to draw that inference is also consumer health data. So a purchase of a handbag, a purchase of lotion, a purchase of over-the-counter vitamins. The purchase of over-the-counter vitamins is probably covered under other categories of consumer health data as well. There's another part of the definition that talks about any data that identifies a consumer seeking healthcare services. And healthcare services, in turn, is defined as any service provided to a person to assess, measure, improve, or learn about a person's health. Not necessarily even their own health, a person's health. Learn about a person's health. Well, that's any information about wellness, about fitness, about nutrition. You can imagine a wide range of websites, online services, apps that would fall into this definition: information about a consumer making a purchase, information about a consumer visiting a website, information about a consumer using an app that would fall into this, used to measure or improve or learn about health. boy, you can imagine a lot of things covered by that. Um, there is a definition of biometric data that is part of the definition of consumer health data. And unlike other definitions of biometric data that we've seen, it includes the mere imagery of a iris, retina, fingerprint, face, hand, palm, vein pattern, voice recordings. So the mere imagery, whether or not it's actually used, if it is capable of being used to extract an identifier, then it is biometric data and therefore consumer health data. So arguably, I'm looking at two sets of biometric data right now. The image of a face, any photograph that has a sufficiently clear image of a human face would be biometric data and therefore consumer health data. So I could go on and on. There's lots of aspects of this definition that you can imagine. Data that is not obvious that it's health related, not obvious that it should be considered health related, not obvious that it's, in any sense sensitive, that would be considered consumer health data. And if this were just enforced by the Attorney General, I think a lot of companies would be less worried about this expansive definition, because they would use their discretion to go after those things that actually will create harm, that are actually sensitive, that people are actually very concerned about. But when you throw the private right of action in there, of course, the fear of organizations that are subject to this law is that the motivation is different. It's driven by dollars, and what's the easy case where you can parse this definition and say, aha, this thing is consumer health data, and you didn't do the appropriate things with that data. So that's driving a lot of the concern and anxiety, and frankly, a lot of work that I'm seeing a lot of companies do now to try to figure out what this means for them and how do they approach it.
Yeah, this is this has been a sore spot for privacy law for a long time. I wrote a piece pretty recently called "Data Is as Data Does," which talks about the problems of sensitive data. And, this is right now sweeping over the US. It's been something in the EU, health is included. But, we live in the modern world of data analytics, and algorithms can make inferences based on relatively innocuous data. And I think, the EU has rightly held, the CJEU has held that inferences count, that, you can't just get around protection of sensitive data if an algorithm can readily figure out all this information from non-sensitive data. So, that's included as sensitive data. California talks about inferences drawn as being encompassed by these definitions, and I think that's what Washington's trying to do, is really get at the fact that if we really want to have a meaningful understanding of data, you need to encompass inferences. The problem is that inferences can be made on almost anything, and that's the power of these algorithms today, and even the Target story, which was, I believe, in 2012. So it's a long time ago. But that was a very innocuous information, unscented lotion, cotton balls, and things like that. And if that's the case, and the algorithms are able to figure out patterns in data, it's seemingly endless, because the algorithms learn. The algorithms are able to detect patterns that we can't detect. So, I might think just commonsensically, oh, well, it's not health data. But pretty much anything that our hunches tell us is not necessarily true. You have to kind of look at what any kind of algorithm might be able to do with that information if it gets fed into it, which could seemingly be anything. And so I think the idea that we can somehow define these categories of data in a neat, easy way is a little antiquated. We can't. So anything that I do could affect my health. Where I go, location information can be very relevant, because that can indicate, what healthcare providers I'm seeing. Everything I eat and consume can give rise to inferences about health. And if it is, someone goes and buys unscented lotion, and that can give rise to an inference of pregnancy. Well, goodness sakes, anything that anyone purchases could possibly, give rise to an inference. So And then we have the very broad definition that you talked about of, we're not just talking about a health condition that someone has, but anyone who's seeking out information about health or wellness. So, yeah, there isn't an easy answer to this. It could be anything. All data could fall into this. And now we have the consequences of this, and I won't even get into how do you solve it, because that's a whole other thing. Is if you narrow the definition, then you exclude inference, then there's so many end runs around the goals of the law. On the other hand, if you do what this law does, it encompasses the universe, and that's a problem privacy law needs to grapple with. Which is why
I will just say on the inference piece, that is one of the few pieces of this of the legislative language that did evolve over the course of the legislative process. I still think it's not crystal clear, but there's certainly an argument based on how it's worded, and I think you could argue it either direction. But there's at least an argument that says it's not covered unless you actually use it to make the inference. Then the inference of a health condition is clearly going to be covered. But if you use non-health data to make an inference, that non-health data then would become health data. And I think that's reinforced by the FAQs, which also are not 100% crystal clear. But so you could at least make the argument that, hey, that purchase of the handbag, if Target hadn't done what they did, that by itself would not be considered consumer health data under this definition. But once you use it for the inference, it does become health data.
But that really obviates the goal of this, right? I take it that the goal is, in a post-Dobbs world, you want to give consumers the right to protect themselves against, if someone's in a state where, certain things are criminalized, that, some app or company doesn't have the data that then can be gathered about them and then used in this way. But the law really can't stop them from doing it. It can't stop a law enforcement, the police from doing it. So if the data is there, and then they can just take it and crunch it and figure things out with it, the law is not really going to achieve much of its goal. Maybe it stops the particular company from doing that, but it doesn't necessarily stop what I think the main reason why people want to protect themselves.
Right.
Anyway,
and I think that policy debate that you just touched on is going to be played out in the courts in trying to interpret this. What was the legislative intent in these areas where it was broad? It was quite clear from some of the language that you're exactly right. The supporters of this did want to protect folks who perhaps travel to Washington to obtain a treatment that's not lawful in their state. They do want to protect that data from being collected and, in their view, misused by the attorney generals of those states or other law enforcement agencies in those states. So I think in these areas of ambiguity, there will be debate, and this will be tested in the courts. And part of that argument will be, what do the words say? What was the intent behind those words? What was the legislative motivation? And there's a record of testimony and other materials that do allude, if not go further, to that concern that you just articulated.
And so let's look at some of the substantive requirements of the law. In particular, it's got this very robust right to delete. The right to delete has no exceptions. And I wonder what you think some of the implications are of that, because almost every other right to delete has a bunch of exceptions, but this one doesn't. And I just wonder, how does that work in practice? I can, if I can make a request to a company, delete my data, and they would say, hey, we need it for tax purposes, or we need it for litigation purposes, or we need it for any. There seems to be no exceptions of any sort.
Yeah, but there is arguable, and I think it's a strong argument, one exception or one set of exceptions, and that is in Section 7 of the Act. There's a set of security-related exceptions. It effectively says nothing in this Act restricts a regulated entity from engaging in reasonable security practices. That some anti-fraud language in there and other things that are related to security. So I think arguably that language means that even the right to delete wouldn't prevent a company from retaining that data if it's necessary to obtain those security related purposes that are articulated in that exception language. But other than that, I think, yes, there's no exception for where retention is required by law. There's no exception for common accounting and tax purposes. There's no exception for other legitimate and indeed critical business purposes. There's no exception for defending your rights or even where there's a litigation hold on the data, where there might be a court order that says hang on to this data, or there's an investigation, even by the FTC that says don't delete any data. There's no exceptions. There's none of those common exceptions that you see in other laws. And so I think companies will have to make some very difficult decisions about which law.
How do you, if there is a litigation, I mean, do you delete data from a litigation hold that could be, a crime or a breach of attorney ethics? There's also, what about if I say, hey, I didn't like the grade I got at University of Washington. I didn't like the grade that you gave me, Mike. So I want to delete it from my transcript. Delete this data.
Because that grade is anomalous and might indicate a health condition that I was suffering from at that time, and therefore it's consumer health data, and therefore I have a right to have you delete it. Sure. Yeah, great question. I think companies are going to have to look at that and say, well, I think all universities will answer no, that's not how the world works. And then what is your best defense under this?
Yeah.
Is it
like I sue?
I think in that case, the argument would be that it's not consumer health data. It shouldn't reasonably be interpreted to be consumer health data. There's a lot of reasons why you could have gotten a bad grade.
Yeah. I mean, there's also, data that the, university will keep as part of its, now that might be regulated by FERPA because there is, the FERPA exception there. But there's still a lot of data that could give rise to inferences about health at a university. So beyond the grade that they might want to have on a transcript. Suppose, a student takes a leave of absence because of a health condition, either mental or physical health, and then comes back and says, I don't want that, reflected on my transcript.
Mm-hmm.
I don't know how you delete something like that, but they could.
Yeah, I mean, I think there are. We're going to have to deal with these somewhat on a case-by-case basis. I think, one question will be, is there a defense that you can argue that this is not consumer health data? Is there arguably a security purpose for this that would fall within that exception where you could say, no, we need to keep this for a security purpose? Can you redact or partially redact a record so that you could argue that the consumer health part of it is no longer there? Can other de-identification techniques be applied? I think there's a variety of ways that you might be able to at least address and mitigate risk in some of those conflict scenarios. But I think there's going to be a bunch of conflict scenarios where it is just black and white. I'm going to either violate the law or I'm not. And I think in a lot of cases, say there's a litigation hold, say you're under an FTC investigation, and they've said hold all of the consumer data that is subject to this investigation. I've seen that many times.
Well, then federal law, I think, would trump. I believe that federal law, if it's a federal litigation or a federal agency enforcement, I don't think a state could stop a federal investigation. It could stop another state investigation, I believe, but a federal investigation, I believe federal law would if there's any interference, federal law would control. Is my sense. When it comes to
or imagine a litigation hold in state court.
Yeah,
right?
Yeah.
There's lots of scenarios where you're going to face that scenario, and I think most companies would say, I'm not going to violate the court order for me to hold on to this. And I think they'll let the chips fall where they may with regard to my health, my data. Is that going to be the case that the Attorney General brings? No, I don't think so. Will a plaintiff's counsel try to test that? Maybe, but there's probably easier cases out there. So I think companies are going to have to make some difficult decisions based on risk. And we can talk about more about sort of practical risk-based strategies for compliance once we sort of get through some more of the obligations here. But I think one thing that's important to understand is that the way this is enforced by private litigants is via the Consumer Protection Act. Same with the AG, but under the Consumer Protection Act in Washington, the My Health, My Data Act presumes that 3 of the 5 elements are met by a violation of My Health, My Data. But a plaintiff still needs to prove 2, and that's causation and injury. And injury is interestingly defined as injury to your business or property. Does that necessarily have to mean a financial harm, a direct financial harm that's quantifiable? No. It could be, damage to reputation that you could argue will, interfere with your professional success down the road or whatever. But it's probably more than just it made you feel bad or embarrassment or a dignitary type harm. So, so in terms of companies determining a risk-based approach to compliance, I can imagine, okay, we've got a litigation hold. We will segregate this off. We will delete it from other active systems, but we're not going to delete this data that's in this litigation hold. Could anybody prove injury from that? That may be a very hard case to make. So I think in those kinds of cases, I think companies are going to have to go through that kind of analysis, all of the different risk factors that come into play, and what is the right thing to do in that scenario.
But I guess then the question would be, for a lot of people, it might be, well, if I want my data deleted, and I'm thinking of another case where health it could be involved is accommodations, right? University might have accommodations, or a business might have accommodations, and a business's employees, and all sorts of other things where that could, obviously involve health. And there would be data about that in record systems that would be, they would want to keep for, potential future litigation. If someone claims, hey, you didn't accommodate me. Well, we did. Look, we have these records. Well, if that's all deleted. But when it comes to, I'd like to drill down into some of the other obligations, and also this private right of action, and what does it mean to be a harm? And maybe let's do the private right of action first, because I think it's really interesting, and you've gotten into some really interesting things about it. This requirement, obviously, pure emotional distress damages looks like they're excluded, but suppose something happened to me yet. Company has my data. I ask for it to be deleted. I say, delete this. This is sensitive data about my reproductive health that I want to protect. And I'm really concerned that, you haven't done that. I asked you to, but, for some reason the company decides, litigation hold, whatever, we're not doing it. And I said, look, the law says this. Should I have to wait until I'm prosecuted, or, that somehow this information is leaked out? The whole point of the law is I don't want it there because it's creating a risk to me. But if the private right of action does not give me the ability to do anything about it, now, I don't know if it gives me a lawsuit just for injunctive relief. So I could just say, hey, I don't care about the damages. I just want to force you to delete it. And then, the attorney's fees can be collected, and we're going to see, attorneys are going to be just as happy about that. So how does that work? Can I get injunctive relief? And then how does it protect a plaintiff that nothing's happened yet, but the whole point of not having the data there is to protect that?
Yeah, I believe injunctive relief is available. So that's an important aspect. And I also think what's interesting, and I don't know the answer to this, nobody knows the answer to this, is the Washington Consumer Protection Act is a relatively old piece of legislation. That language about injury to, your business or property just, makes it sound dated. And I think it will be interesting to see whether Washington courts interpreting the Consumer Protection Act in light of My Health, My Data might be inclined to take a more expansive view of what an injury is. Because the legislative findings suggest that misuse of health data is damaging, is harmful. So will that impact subsequent interpretations of the Consumer Protection Act? Will the set of precedent under the Consumer Protection Act evolve in light of this new set of harms that the legislature has defined as violations of the Consumer Protection Act? That will be interesting to watch. It will. Yeah. My best guess is that I think it will shift the thinking around the Consumer Protection Act and what constitutes an injury under the Consumer Protection Act.
Yeah, because I think that really the choice is pretty stark, because the things the act asks companies to do are most likely, don't delete data, don't sell data, et cetera, are most likely to be things that are not going to result in the kind of injury that language defines, business or property, or even reputational, if we include it. It's likely, the idea is to kind of nip it in the bud before something really bad happens. So obviously there could be a few cases where the data is leaked to the public, or something happens. There's a data breach and it gets out there, and they shouldn't have had the data because someone asked for it. But it's going to be a rare case. If you take that interpretation of harm, it's going to be a rare case that could ever give rise to a private right of action for damages, and they would almost all then have to be injunctive. On the other hand, if you interpret this to be more expansive, to cover, I'm injured if I request data to be deleted and that instruction is not followed and it's still in your system, I'm not going to be able to point to any real, concrete, it's just still in your system. Nothing's happened to me as a result. I just want it gone. A court's going to say that, unless we expand it to that, this private right of action is hollow, and it's meaningless, and it's not really addressing most of the things that the act is requiring, and therefore it's an empty gift to the consumer. The consumer goes to use it and fails every time. So courts might say, we don't like that. That doesn't seem to be what I think. I'm going along with what you're saying, is the courts might very well expand it, apply it more broadly. And if they interpret that, if they start changing the interpretation of the Washington Consumer Protection Act, then it's going to mean that all harms under that could be expanded as well. So it would expand it beyond this to all sorts of other things. So good day to be a plaintiff's lawyer, I think.
Yes. Yeah. I think a lot of them are shifting their gaze from Illinois to Washington, or at least expanding the gaze.
And so tell me a little bit more about some of the other obligations in this law. What else does the law require?
Yeah, there's a couple of additional really important substantive obligations. Probably the most impactful is the consent requirements. And the consent requirements come in two flavors. As I mentioned before, there's sort of GDPR level consent for anything that is GDPR opt-in consent for anything that that involves the collection or processing or sharing of consumer data that is beyond what's necessary to provide a consumer requested product or service. The one caveat I'll say is that there's also that security exception that I mentioned. So arguably you can use it for security purposes without opt-in consent. But anything else would require opt-in consent that is specific, unambiguous, et cetera, all those GDPR derived terms. I think the important and interesting thing on that part is, how are courts going to define necessary? Do they mean strictly necessary or reasonably necessary? If it means strictly necessary, you could imagine where somebody is purchasing a health-related device at a store, at a retail outlet. And that purchase data would reveal something about somebody's health, or at least an attempt to obtain healthcare services, and therefore would be consumer health data. So you can use that purchase data to complete the purchase. That is the service that's being requested by the consumer. Can you subsequently use that purchase data for inventory control? Can you subsequently use that data for accounting and tax purposes? Can you subsequently use that data for all the host of operational purposes that you use that kind of purchase data for? If the law is interpreted, if that necessary term is interpreted to mean strictly necessary, arguably you would need consent for all of that stuff, which is, frankly, nuts. So I think the expectation, or at least my hope, is that courts will apply that with some level of reasonableness and interpret more as reasonably necessary if it is tied to and supporting the service and the operation of the business that's providing the service. That should all be considered necessary. Obviously things that are beyond that, like monetizing the data, advertising, marketing, would fall beyond even reasonably necessary, and so that would require opt-in consent. Sharing for secondary purposes, that the law doesn't use the term secondary purposes, but I'll use that as a shorthand for things that are not necessary or reasonably necessary. But I think there's a big question mark there. How strictly will the courts and the Attorney General and the plaintiff's bar, who will be testing this, certainly interpret that necessity requirement? That's the important piece. So there's that consent piece. Anything that's beyond, providing the service is going to require opt-in consent. The other consent part is called authorization, and that is beyond opt-in consent. That is a written document that is signed by the consumer that needs to articulate the specific consumer health. So this is for any sale of consumer health data. It needs to articulate the specific consumer health data being sold, the name and contact information of the seller and every purchaser. It has a long list of disclosures that need to be in this document. It needs to be retained by both the seller and the purchaser for 6 years, and it needs to be signed by the consumer. It's valid for no longer than 1 year, and it's revocable at any time by the consumer. Arguably, obviously that's very burdensome. In scenarios that have been interpreted to be a sale under the CCPA, and this borrows that CCPA language, include things like cross-context behavioral advertising. An authorization like this simply could not scale in that kind of environment. So does this in effect create a prohibition for behavioral advertising using anything that is consumer health data? And recall how broad that definition is. I think the implications on online advertising are profound. What will this mean? How will this be interpreted? How much risk are companies willing to take, where their entire business model is based on advertising and monetization? Those are really interesting things that we're going to have to watch very closely. And again, I think there are some risk-based strategies companies can take, because if you interpret this in the most broad way and in the most conservative way, I think it would require just simply shutting down a lot of business models.
Yeah, and also I think I wonder how that requirement to keep it for 6 years meshes with the requirement to delete data.
Well, I flagged that in one of my blog posts. Not only does this lack of exceptions under the deletion requirement create conflicts with other laws, it creates a conflict within this law itself, because of course that authorization needs to have the consumer health data. It needs to be retained. This is one thing the Attorney General did helpfully address in their FAQs, and they said, well, you simply redact the health data from the authorization and continue to retain the remainder of the authorization.
So I'd like to talk a little bit about I saw in the question someone asked for a little bit more on the biometric data parts of this. What are the implications of that? Because I guess it would be video, photos, would be included in this. And so, how is that going to work? Because presumably any photo online could be, extracted and used to, create a face print.
Yeah. And as I said before, the definition of consumer health data includes biometric data, and biometric data is defined very broadly, which includes imagery of the iris, retina, fingerprint, face, voice recordings from which an identifier template can be extracted. Not that it is extracted, but that it can be extracted. So, arguably any photograph is covered by this. So what does that mean? Well, we've got the broad deletion rights. You have consent obligations for any purpose beyond what the requested service was. Is this one of those areas where companies are going to accept some risk? I've got my photograph on my profile on a variety of social media apps. It's out there publicly on conference websites and other people's social media posts. It's being projected to a large number of people right now. And maybe that's part of the service that I am requesting by participating as part of this conversation. But if somebody took a screenshot and it did something else with that photograph, is that a violation of my health, my data, because you've now used my health data for something I didn't consent to? Yeah, arguably. Again, I think companies are going to have to use these various, risk-based decision points about what they're going to do with that. Are they going to shut down everything? Are they going to not allow profile photos anymore because of the fear of not being able to adhere to some of these obligations? In some cases, maybe they can. I mean, the deletion right, yeah, it's broad, but yeah, you can always delete a photograph, unless it's in an AI training database, and pulling that out would mess things up. But I mean, there's lots of scenarios where I think the breadth of this definition of consumer health data, the breadth of the definition of that definition of biometric data is going to cause some real challenges. And I think companies are going to have to make some hard decisions about whether or not they're going to lean into a little bit of risk here. I think there's if you look at this definition and you parse it out, there's some things that are very clearly in. There's maybe a handful of things you can conclude are very clearly out, and there's a vast gray area. And so I think it may make sense for companies to think about, well, maybe as priority number one, I'll focus on things that are clearly in. And if there's a gray area, maybe I'll do some things. Maybe I'll change some practices. Maybe I'll increase some protections. Maybe I'll adjust my data subject rights process to expand and do some things that seem to be required under this new law. But maybe that won't be the primary focus. Maybe we'll take a little bit of more risk in that gray area, because again, when thinking about the motivations and the incentives and the barriers for the two different sets of enforcers, the Attorney General and the private plaintiffs, you got to think about what are the barriers they need to overcome. Is this going to be the easiest case for them to make? It's kind of like that old joke: you don't need to outrun the bear while you're in the forest; you just need to outrun the other guy. Look around what other people are doing. Don't be the outlier to make yourself the easy test case. But I think we're all going to be learning and watching and evolving our thinking on how to best comply with this law over the next months and years as additional guidance comes out. Maybe different industry consensus will emerge, and then certainly when we start seeing enforcement And then later court cases will continue to have to evolve our thinking on this.
So one other quick question that came to mind is AI. You know, a number of companies, OpenAI, Clearview, are scraping the internet for all sorts of information and imagery and everything else. You know, scraping up, you know, the LinkedIn profile information and other profile information, scraping up photos off of Flickr and other sites. Uh, and I wonder, you know, if this law could be a powerful tool to try to stop some of these activities, to stop. I mean, the Illinois BIPA was used to try to stop Clearview AI, and Clearview AI is this company that's sweeping up all sorts of everybody's photo on the internet and then selling it off to various law enforcement agencies to do facial recognition. Um, so I wonder, you know, can they do this in Washington anymore, or not? And ultimately that suit settled in Illinois, and settled, and basically I think, you know, Clearview lucked out because the ACLU kind of let them off the hook, and they kind of still do what they are doing. Um, but I wonder in Washington what the implications could be, because as I hear you talk about the law, I'm not sure you can scrape in Washington, and so, you know, OpenAI scraping data from people in Washington, or Clearview, that would be a violation, right?
If you are collecting consumer health data that is not necessary for a consumer requested product or service, then yeah, that's arguably a violation because you didn't obtain the appropriate consent. And so I think this law could potentially be a more powerful blocker of scraping than the CFAA has been in the past, than BIPA is in Illinois, than other privacy laws have been. So yeah, I think there's definitely a potential for that. Of course, there would have to be an argument that the scraped data constitutes consumer health data. You know, when we talk about photographs of faces, we've already talked about why that seems like it very well could be within this definition. For any other kind of scraped data that may be used to train AI algorithms and build models, you know, the question would have to be asked: would this be captured by this law? Again, given the extraordinary breadth of the definition, I think there's an awful lot that could be or would be.
Yeah, and so I think it's going to be very interesting to see how this plays out.
And it might not be limited to Washington too, because as we talked about, it has an extraterritorial impact. And I should mention one other thing that's about the extraterritorial impact: that the definition of a consumer in consumer health data is not only residents of Washington, but it's any person whose consumer health data is collected in Washington. And collected is a defined term that includes processed. So it doesn't actually have to be collected in Washington, but if it ever touches Washington state, if it's ever held in a cloud service that has data centers in Washington state, by a vendor that's located in Washington state, it potentially covers consumers who have no connection to Washington state otherwise.
Could they sue? So if that happens, I'm not in Washington State. I'm in Washington D.C. But could I say, you know, look, you know, if it protects me, shouldn't I have a private right of action even though I don't live there, or would I not?
I think the answer is yes, and I think that is important because in the case of the private right of action, it will dramatically impact the size of the class and therefore the financial incentive to bring these cases. If it were limited just to people in Washington state, that might be a relatively small percentage of a company's overall customer base, or a small percentage of the data that's being scraped, you know, or otherwise collected. But if it's anybody whose data is processed in Washington state, depending on, you know, which cloud services you're using, et cetera, it could be your entire customer base. So I think that could have a pretty dramatic impact on the incentives to bring cases, and therefore the risk profile of some of these activities.
Very interesting. Well, we're at the end of the hour. I want to thank you so much. This has really been fascinating. We will wait to see what happens. I think it's a pretty sure bet that there will be quite a lot of activity around this law, quite a lot of cases to flesh it out. We're going to see in years to come what's going to happen. But definitely, I think we'll see a lot of activity and a lot of these ambiguities in the law eventually working themselves out. Um, it's a good time to be on the sidelines watching and watching this play out. I think there's some really interesting issues that will eventually get fleshed out that I think are important ones to be fleshed out. I wouldn't want to be in the thick of it in the
It's fun.
seat, but
there's some really challenging issues, and it really is creating some very interesting discussions. Companies are taking this very seriously and being very thoughtful about it. And there's some very difficult and impactful decisions that are being made, and being in the middle of that is super interesting as well.
Well, great. Well, anyway, please don't make a request to delete this under this law, because I guess even if we have a contract and you sign away your rights to me under a contract, I guess you could still under this law say I want to delete it, and I guess that would take. I don't know how that would weigh against the contract that would say otherwise, but. We'll wait and see how that one gets.
Let's not test that one. Okay.
Anyway, thank you so much for joining me, and goodbye, everybody.